Here's something I observed for 19 years from the other side of the desk. Most clients waste the first 10 to 20 minutes of every lawyer meeting. This is what happens when people arrive in survival mode. They start to download and catch their lawyer up on everything that's happened since the last meeting, and the lawyer listens and they respond to what's in front of them. And then the time is up. Maybe it's an hour and the hour ends. And a significant portion of that, if you're looking at 20 minutes out of an hour, produce nothing strategic. And it cost you money. More importantly, it cost you momentum. I'm Iman Ibrahim. I spent 19 years as a family lawyer in Singapore and England and Wales. This is Divorce Actually, where we talk about what actually helps when you don't need more legal advice or more emotional processing. The decision making, the preparation, communication, and negotiation frameworks that actually move you forward. Today, we are going to talk about how to prepare for your lawyer meetings so that every session moves your case forward and so you leave each one knowing exactly what was decided and why. So, shocking news here. Shocking news. Why do a lot of clients, most clients, waste time in lawyer meetings? The core problem here is confusing what you need to say with what your lawyer needs to hear. They're actually very different things. And what you need to say is the full context, the grievances, the things that feel important, and the emotional weight of what's happening. However, what your lawyer needs to hear is the facts with legal implications, new developments that affect strategy, the specific decision or question that you need to resolve today. Now, look, I understand. Catharsis is real and it matters, but your lawyer is not the right venue for it. And at their hourly rate, it's very expensive catharsis. And this is not a criticism of clients. It's the natural result of having no real structure for how to prepare and not really knowing where to direct the appropriate information. So, very simple, really easy one. Arrive with an agenda. Don't come to download your story onto your lawyer. What does a good agenda look like for a lawyer meeting? So, here we go. Get your pen and paper ready. Have one primary purpose per meeting, if you can. So before you arrive, complete this one sentence. The one thing that I need to resolve or decide today is ... Not, okay, don't do this one. I need to update my lawyer on everything that happened. Also, we don't need to do this one. I need to talk about the children and the finances and the house and the messages he sent. Those are potentially multiple meetings, or they are context, not agenda. Trust me when I say that the single decision or question format forces you to prioritize, and it makes the meeting measurable because either you resolved it or you didn't. The secondary items, which are the things your lawyer needs to know that have legal implications but don't need a decision today, these could look like new conduct, a development with the assets, maybe a communication that changes your position. These could go into a brief written summary that you send ahead of your meeting via email. And when I say send ahead, I don't mean in the 5 to 10 minutes before the meeting because your lawyer is a busy person and they probably do not have the opportunity to read it so close to the meeting. So try and send it a little bit in advance, or you could hand it over at the start of the meeting. But as I say, let's not make it a 20-minute verbal download session. And the question that you can put forward that ends every meeting is, get your pen and paper, what are we doing before we meet again, and who is doing it? This question alone will transform how useful your lawyer relationship is. And it's also good to know who is doing what work so you can expect what charges to come along later on. A question I'm also often asked is, what documents should you have organized before you start engaging a lawyer at all, not even before a meeting? I'm going to say this, And I'm sorry if it hurts your feelings, but the more organized your documents are from the beginning, the less lawyer time is spent on administration, and administration at hourly rates is expensive. Now, I'm going to say that there are 3 core documents to maintain from the moment you know that separation or divorce is going to be happening. Number 1, key document, a chronological timeline. So key dates and events in the marriage and in the separation in order. So date of marriage, date of children's births, when significant assets were acquired, when the relationship broke down materially, when you separated, and it could be that you separated under the same roof, not necessarily physically, but if you physically separated, then put that down. When legal proceedings were initiated, if at all. You could have your lawyer reconstruct this from scratch every time, or you could hand it to them on day 1 and save time and money. And yes, I know putting it together can be tedious, but great news, there's voice dictation, and you can use your favorite AI to help you draft this. So do that. That's cheaper or free versus asking your lawyer to do that for you. The second document that is very useful is an asset schedule. So every financial asset that you're aware of, both in your joint names as well as in individual names. This should include property, investments, if you're in Singapore, CPF, business interests, outstanding liabilities. It doesn't need to be complete and it doesn't have to be perfectly precise at the start, but having your best current picture in one place means that your lawyer isn't asking you basic questions you could have answered in advance. Finally, and those of you who have been following my episodes know this one well, the communication log. Now, it's not a transcript of every argument. It's more of a structured log of communication that has legal relevance. So significant messages, notable behaviors, anything that affects the children's welfare or the financial position. These should have dates, brief factual descriptions, and I repeat, factual descriptions, relevant screenshots, and reference these by date. This document is super useful. This could turn into evidence later on if it needs to be. So put that in order. Again, use your favorite AI to help you with this. These are the 3 documents that make every professional interaction move faster, more precise, and more useful to you. If you've got those basics down, you might now be asking, well, how do I distinguish between what I want to tell the lawyer and what they actually need to hear from me? So here is a filter. Use this. Does the information change the strategy, or does it change how I feel? Information that changes strategy. This could be your ex has been moving money out of a joint account. He has refused to provide any financial disclosure, or a new settlement offer has arrived. These are legally relevant facts. Information that changes how you feel. He was dismissive and rude. He didn't respond to your message for 3 days, or he responded with 20 messages, or he told your child something that upset them. He's being difficult about the school fees again. Now, this category, I know, it may matter to you, and there may be some legal relevance eventually, but it is not a lawyer meeting item unless there is a specific legal question attached to it. For example, if he said something that upset my child, does that change your position on the custody or the care and control arrangements? Okay, that's a legal question. But take note, he said something that upset my child. That is context. So there's a difference. I know this distinction is really hard to apply when you're in it, and that's fair. So you can try this exercise. Ask yourself for each item that you want to bring up, if this is a true fact, Does my lawyer need to do something differently? If yes, put it forward into the meeting. If no, it goes somewhere else. Hopefully it's all starting to make sense now, and I'm going to talk about what does it actually mean to give your lawyer good instructions. So in the previous episode, we talked about how a good lawyer can't work well with bad instructions. What does the other side of that look like? Good instructions share a few things in common. They are clear on the outcome you are trying to achieve, not just the position you want to take. They are honest about your constraints, okay? What you can sustain financially, emotionally, practically, and they are consistent, which means they don't shift every time the other side does something to provoke you. Here is an expensive pattern that happens quite often. A client would agree on a strategy. The ex sends some kind of inflammatory message that night, and by the next morning, the instruction changes completely. Every time that happens, your lawyer has to reconfigure. That reconfiguration costs you in fees, strategic coherence, and eventually in credibility. And if you are before a judge, please know, credibility, very, very important. I want to emphasize though, good instructions aren't about being certain, because fairly, circumstances change, you need to adapt. But the difference is changing because the facts changed, not because your emotional state did. The full architecture of how to build and communicate instructions well, or good instructions, is a deeper conversation, and I'm not going to go into that here. But the principle to hold on to is your lawyer executes what you tell them, and the quality of the input determines the quality of what comes back. So now you know what goes on in lawyer meetings and how to prepare for them, what should happen between lawyer meetings. And yeah, nobody really thinks about this one, but let me tell you, the time between meetings can be where a lot of unnecessary cost and drifting away from strategy can happen. The most common pattern that I see is this. Something happens. A difficult message, a tough conversation, a development with your children, a financial surprise, and the immediate instinct is to contact your lawyer. Sometimes that's the right thing to do, but quite often it isn't. The 2 a.m. WhatsApp to your lawyer is rarely a good idea. Of course, what happened is real, but decisions made in this reaction to the worst moment of the day are rarely your best strategic thinking. Your lawyer will respond to what you send them. So if you sent them reactive, you are paying for reactive legal work. I am going to give you a better system. Maintain a running document between meetings. Every development, every relevant communication, every question that comes up goes into that document. And so when you meet eventually, you have a curated, organized picture of what happened rather than this live verbal download. And when you've had enough distance from those worst moments, when that passes, you actually have the ability to assess what has actual legal relevance. Let that sink in. So when should we have immediate contact with the lawyer? Okay, if there is something with a deadline attached, please. Court documents, if you are served or you receive court documents that require a response, please pass those to your lawyer immediately. Don't sit on them. If you have urgent safety concerns, if there are formal communications from the other side that are sent somehow directly to you instead of to your lawyer, and they require a reply within a defined time frame, those are real things, real emergencies. But other than that, most things are not. So you have to have some discipline in triaging your own emergency. And whilst it can be difficult, it is very cost effective, the best cost effective habit you can build during a divorce. So you will have noticed earlier that I talked about AI, and there is a lot of talk about AI during divorce, what's actually useful and what isn't. I'm going to say that this is worth addressing because it does come up quite a lot. And to be honest, the AI generated answers that people get can be useful, but also can be genuinely dangerous. And if you have kept up with the news, there have been cases where even lawyers have been tripped up by using AI and finding that cases cited by the AI were made up. For now, AI is not a lawyer. It cannot give you legal advice specific to your jurisdiction, your facts, or your case. It does not know your financial picture, your parenting arrangement, or what your ex's lawyer is going to do. But what AI can do well is help you think more clearly. And if you need to get organized and have it do your admin, your timeline, your structured summary of your financial position, a list of questions for your lawyer, or even to work out how to phrase something in writing. Maybe you want to neutralize it, summarize it, make it easier to understand. Well, AI is your bestie for that. It's genuinely useful and it can help you process complexity when you have no one to think out loud with at 11 p.m. That's fine. And I'm going to also say that AI is also useful for understanding concepts. If your lawyer uses a term you don't really recognize, or you want to understand how a particular process generally works before asking your lawyer to explain it on the clock, then AI can give you the orientation. But I will repeat that it cannot tell you how the concept applies to your specific situation. Frame it like this. Use AI as your preparation tool, not a decision-making tool. It will help you arrive at certain conversations, could be with your lawyer, mediator, or with a financial advisor, more organized and more informed. But the decisions still need to be made by you with qualified professionals who know your actual situation. What questions should you be asking your lawyer, not just answering? So, a lot of people using their lawyer meetings like an interrogation that goes one way. The lawyer asks, the client answers. It's not the most useful structure. A good meeting with your lawyer is bi-directional. That means there are questions worth bringing to the table regularly. Regular questioning. This could look like, what are we trying to achieve this month? And this gets your lawyer to articulate a short-term strategic objective, not just a list of tasks. If they can't answer it clearly, that's telling you something. Another question you might be asking regularly is, what is the risk of the position we are currently taking? Every legal position has an upside and a downside, and your lawyer should be able to articulate what happens if the court doesn't go with you. What if the other side calls the bluff on something that you're trying? Or what if the circumstances change? All you're hearing from your lawyer is the upside. Make sure you are asking them directly about the downside. Here is another great question. What would change your recommendation? One of the most useful questions in any professional relationship, actually not just with your lawyer, with your doctor, with your financial advisor. They are also people who make recommendations to you. So this surfaces assumptions that your lawyer might be making and tells you what information matters most going forward. Finally, you can ask, this is also important, is the cost proportionate to the likely outcome? Actually, hardly any clients ask this because a lot of clients are preoccupied with using the law to slap the other person's face. And sometimes that costs money and sometimes it's not worthwhile. Of course, if you have very deep pockets, do what you want. A lawyer can pursue any position you want them to. They are your fighter, your gun for hire. But whether it's worth pursuing is, okay, partly legal judgment, but also partly your call. You can only make that call if you ask the question. And finally, how do you close a meeting? So before you leave every meeting, confirm the decision or conclusion reached, who is responsible for each next action, and a timeline. And immediately after, if you weren't taking notes in the meeting, write a brief summary for yourself or dictate it. Again, use your bestie AI. It's not a legal memo. You can just make it very simple. We decided on X position or X action, and my lawyer is going to do Y actions by Z date. And I need to do W actions by V date. This serves a great function. Number one, it creates a record so that if there's ever a dispute of what was agreed to during the meeting, you've got that to refer to. And also, it forces you to process the meeting properly rather than leaving it in a fog. You could ask your lawyer to confirm decisions if you need that. So you could send a follow-up email saying, my understanding from today's meeting is blah, 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 blah. That's appropriate. The good lawyer will confirm or correct it. It's not about mistrust, it's about file management. But of course, yes, everything that your lawyer looks at does require some kind of billing. Yes, everything, of course, that your lawyer reads will incur some kind of billing charge. So you decide how you want to play this. Also useful is to have a running document of all the decisions made across the life of your entire separation or divorce matter. Now, I'm not talking about the correspondence. I'm talking about decisions on what date and for what issue was what decided and what was the rationale behind it. I hate, again, to break this to you. Divorce is a really long process, longer than you think it is. And 6 months from now, you may not remember why you agreed to something. And then you might have to have your lawyer dig it up. And that costs. So have a note for yourself, like a little journal or diary, and you can always refer to that, especially if it's a searchable Word document. You are the strategic director of your own case. Your lawyer just executes. That means it is your job to arrive at every meeting knowing what you need to decide, not just what you need to say. The meeting is most useful when you treat it as a decision-making session, not as a status update. The clients who get the most from their lawyers are not necessarily the ones with the most complex cases or the most money to spend. They are the ones who arrive prepared, who know what they need from each meeting, and who leave with clarity about what happens next. Preparation, unfortunately, doesn't happen automatically. It requires treating yourself as a participant in the process, not just as someone that the process is happening to. You hired a lawyer to apply their expertise to your situation, but you are the one who knows your situation. The more clearly you can bring that to every meeting, the more effectively they can do their job. If you're preparing for your first lawyer meeting and want a structured way to get ready, have a look at the website, www.divorceatelier.com. It's a great starting point. We have a divorce readiness diagnostic. It's free, it takes a few minutes, and it gives you a clear picture of where you're prepared and where you have gaps before you sit down with anyone. If you have any questions, if you need any clarifications, head over there and send a message. I'm Iman Ibrahim, and this is Divorce Actually.